Hello, this is a video discussing the critical issues you need to be aware of when considering property settlement, or if you are advising clients about a property settlement in the current climate. My name is Denby Kerr, this is Kerr Fels, and we are both directors of Kerr Fels Divorce and Family Lawyers. We are also both accredited family law specialists. The video contains information only, and for targeted advice, factoring your specific circumstances or those of your clients, please contact us or another family law specialist. Amy will discuss parenting issues in a separate video, so please refer there if you require only parenting information.
Thanks, Denby. Now more than ever, it's important to approach discussions and negotiations with your ex-partner in a sensible manner and to keep lines of communication open with your ex-partner to the greatest reasonable extent. Doing this can prevent minor issues from escalating and requiring court intervention, be that in relation to payment arrangements such as liabilities like a joint mortgage, the payment of spousal maintenance or child support where your income may be impacted by the pandemic, or flexibility with parenting arrangements. There is a lot of help out there, and it's important to be in contact with your employer, banks and financial service providers, and to keep on top of the government advice and directives to minimise the impact of this pandemic on each of us. If you are going through separation or you're involved in family court proceedings, it's important that you seek advice from an accredited family law specialist in relation to the impact of the pandemic in your circumstances.
Thanks, Amy. If you have already commenced proceedings in the family court, a practical issue of importance is that the court has recently advised us that apart from trials, all hearings and attendances should be now conducted by telephone. Consequently, if you have an upcoming hearing in the family court, including a conciliation conference or a case assessment conference for parenting, you should be working with your family lawyer to file a request to attend that hearing by telephone. If you are self-represented, we encourage you to take independent legal advice to assist you to attend at that hearing by telephone effectively. With the health pandemic status and resulting economic impacts changing on a daily basis, we are receiving many questions about what are the relevant and appropriate steps to take concerning property settlements. In the current financial climate, the outcome of those questions differs as to whether you have property proceedings on foot or not. There are time periods which are applicable to all property settlements, and these remain unchanged by COVID-19. In the case of married couples, you have 12 months from the date of your divorce to commence proceedings. In the case of de facto couples, you have 24 months from the date of your separation to commence proceedings. These time periods remain operational, and if you are approaching the end of either one of those periods, it is critical that you seek advice about what steps can be taken by you, even in these uncertain times. If you have not yet commenced proceedings in the family court and you are negotiating a property settlement or advising a client who is in the throes of negotiating a property settlement, what is critical is that you have a current and updated asset pool with the values of assets, liabilities and resources updated to account for recent events, and that you continue to update those values where practicable. Further, it is important that you consider the future economic need in the event that your employment or that of your spouse or former spouse may be temporarily or permanently affected. We suggest contacting your accountant, your financial advisor, and of course your family lawyer to discuss these issues. Continuing negotiations on the basis of asset pools previously agreed and understandings about future need and capacity for employment, and not taking into account the decrease or increase in value, is likely to be problematic and may result in enforcement issues which have a consequential cost, delay and frustration to you. If you are negotiating a property settlement or assisting a client in that regard, please contact us or another family lawyer to have regard to what updated financial information needs to be provided. If you require advice, contact us. If you are involved in property proceedings in the family court, there are a number of other issues to consider. Asset pool changes are one, the form of orders, and in particular how superannuation orders should be drafted is another, and similarly what applications may need to be made taking account of what are no doubt significant changes to financial circumstances. It is likely that in the coming weeks or months you will need to prepare an updated financial statement, so the court has updated evidence as to your financial circumstances and any change to your position as a result of the COVID-19 crisis. This is important in a number of ways. Namely, if the value of your interest in a business has been affected, it is relevant to an overall property settlement. Also, if your income has varied, that is also relevant to spousal maintenance issues and other considerations. Specifically, if you're bound by an order that you pay spousal maintenance but are no longer in receipt of the income you previously had access to, it may be that a variation application is necessary. It's critical that you work with your family lawyer to consider what steps need to be taken to apprise the other side of your revised financial circumstances, and so that negotiations can continue on a proper footing and necessary applications made to the court or alternatively avoided where obviously communication can be achieved. In relation to superannuation splitting orders, which are a common tool utilised in property settlements for formerly married or married parties, we recommend that you contact a family lawyer to discuss the form of these. This is because superannuation splitting orders can be crafted in a number of ways, and given the significant reduction to the share market today, it may not be appropriate to agree on a superannuation split for a specific amount in the current climate. A percentage allocation of superannuation may be a more appropriate mechanism, but whether that is the case will depend on your individual circumstances, and this is why advice about this issue is important. If you have final property orders which are yet to be implemented, or have had an interim hearing or trial but are yet to receive a judgment and orders, it may be that steps need to be taken to bring evidence before the court if there has been a significant change to your financial circumstances. If the final property order is now unworkable, please contact a family lawyer to discuss whether there is sufficient merit for the court to consider setting those orders aside. If you have had a hearing and are yet to receive a judgment about financial issues, please again contact your family lawyer to seek advice and discuss whether it is appropriate to provide further and updated financial evidence to the court. As a practical step, if you are facing hardship, as Amy referred to previously, contact your bank to discuss options so that court intervention may be minimised and legal costs to you and your former spouse similarly. The takeaway is that we are all in uncharted territory, and this is why it is critical for individuals to take advice about the considerations which are relevant to them. We are available to provide that advice to you in a number of ways, including by telephone or utilising services such as Zoom conferencing or Skype, depending on your individual needs and technological prowess. We otherwise hope that everyone stays safe, and please contact us if you require our assistance in any way. Thank you.